can join.
Are we live, Brian?
I believe so.
Then I will call the meeting to order. This is the November 17th meeting of the California Law Revision Commission. My name is David Carrillo. I'm the chair. Mr. Executive Director, would you please call the roll and see if we have a quorum?
Yes, I will do it in the order that you appear on my screen, just because I don't have a printed list. So Commissioner Carrillo.
Present.
Commissioner King.
Present.
Commissioner Huebner.
Present.
Commissioner McAllister.
Here.
Commissioner Cubas.
Present.
Commissioner Jenkins.
Here.
Commissioner Simpson.
Here.
All present and accounted for. We have a quorum.
Great.
And we do have an audience, pretty sizable one. So I think we are sufficiently live that we can proceed.
Brian, in view of the fact that I have to leave directly, would you mind if we took the agenda slightly out of order and called the minutes so I can vote on that?
Move approval.
We have a motion. Is there a second? Any discussion? Jane seconded. Any discussion? Going once, going twice, seeing none. Would you please call the roll, Brian?
Carrillo,
Aye.
King. Huebner,
Aye.
McAllister,
Aye.
Cubas,
Aye.
Jenkins,
Aye.
Simpson.
Aye.
Passes?
I would point out, we're going to lose Commissioner Carrillo momentarily, but I'm expecting in 10 minutes that we'll be joined by Assembly Member Cunningham for some remarks on antitrust. So it probably makes sense to try and dispose of some administrative matters until we get to 10 and then switch to antitrust.
That sounds great. I appreciate everyone's expediting that matter. I will now drop off and hand the gavel to Vice Chair Huebner. Thank you, everyone, and I'll see you at our next meeting.
Thank you.
Brian, Commissioner Jenkins has been raising her hand.
I just want to make sure, thank you. I just want to make sure you're aware that I'm also dropping off at 10, but I'll be back.
Yeah.
Thank you.
Okay.
Brian, lead us through your administrative matters.
Executive Director's report. Not much to report. I'm continuing to be stymied in my efforts to fill our vacancies. As I mentioned before, the hiring has gotten tied up in the budget process. And so we're waiting for clearance from the Department of Finance on a couple of matters before we can move forward. So we're continuing to be shorthanded, unfortunately, and I don't know when that's going to clear. Hopefully no later than the governor's budget in January, but we shall see. The other item that I wanted to talk about is that there was, when we approved the schedule of meetings for this year, we included a conditional meeting in December with the expectation that we would only hold it if it was necessary to complete work this year for the purposes of next year's legislative program. I don't believe that's the case. And, there would be some value in holding the meeting solely to deal with some of the lingering issues related to Fish and Game, but I don't think that that's enough of a reason to justify an entire meeting in December. And also, as we'll be discussing later when we address the Fish and Game topic, it's expected we're going to be revisiting that in January anyway. So my advice, my recommendation would be that we not hold the conditional December meeting and we meet again next January. Anyone
Are there
have
any objections from commissioners about taking December off calendar? No objections stated, Brian.
Yeah, and I'm not going to call the roll on that. That's just an administrative decision that I wanted to make sure that there weren't any concerns about. Legislative Program Memo 2244. As we talked about at the last meeting, all of the commission's recommended bills were enacted. What this memo talks about is some cleanup that needs to follow in the wake of those enactments. Part of that has to do with what's called chaptering out. When two bills amend the same section, only one of them can operate, and it's the one that is chaptered last by the Secretary of State, which corresponds to the one that's signed last by the governor. And there, you also see that there is an opportunity when you have a really large, complex technical bill with lots and lots of sections in it. You can add a provision that we call a subordination clause, which basically says, notwithstanding the order of chaptering, this bill yields to any other bill in the event of a conflict. And so we had a couple of bills that were big technical bills that had subordination clauses in them. And they were both had to do with fixing conforming revisions to other enacted commission recommendations. And so we had some sections get knocked out. So they didn't operate. And I listed those in the memo, and it's my intention to seek reintroduction of those next year. I don't think there's any commission action that's required to do that because those are already provisions that you've approved. It's just seeking reintroduction to fix the fact that they got knocked onto the floor. So that's just informational. The other thing that's addressed in here is that as happens, some of our provisions got changed in the legislative process in a way that makes the commission's approved comment for the section inapt in some way. And the way that we address that when it happens is that we will, if the recommendation still isn't in final form, it hasn't been printed, then we will sometimes, with commission's approval, integrate revised comments directly into the recommendation. If it's too late to achieve that, we will prepare a supplemental report that is attached as an appendix to the annual report. And so then the record is complete, and people just have to understand that they need to read the recommendation together with the supplemental report that sets out new or superseding comments. So that's the other thing that's addressed in this supplement, is that there are a number of sections where we've provided new or superseding comments. And those would require an approval, and they would then be reproduced, as I said, as part of the annual report. We put them into a more polished form, but the memo sets out the comment language I'm proposing, and I need an approval vote.
I'll move that we approve the proposed modifications to the comments.
Is there a second?
All right, I will call the roll. Commissioner King, Commissioner McAllister,
Aye.
Commissioner Ebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner Cubas,
Aye.
Commissioner Simpson.
Aye.
So that is approved with a note in the minutes that Commissioner Carrillo was not present.
Now, Brian, before we move off administrative matters, the agenda indicated there would be a closed session to discuss a personnel matter. For
Yes.
the minutes, that session occurred. Is there anything else we need to say about that in open session?
No.
Okay.
So the next item on the agenda, that concludes the administrative matters. The next item is substantive. It's the antitrust study. And we have 3 minutes before we're expecting to be joined by Assemblymember Cunningham. Let me check my email to make sure there's no developments there.
There is.
He is joining us, Brian. Welcome, Assembly Member.
Good morning. Glad to be here.
Good morning. Thank you. So I think we might as well start. It's a couple minutes early, but that's fine. This is in connection with the commission's study of antitrust law, which was just assigned to us this year. And that we'll be talking about memorandum 2250 and its supplements shortly. But I did ask Assemblymember Cunningham if he would like to make some prefatory remarks to the commission, since he was one of the principal co-authors of the resolution that assigned it to us. And he was able to make it, and I appreciate that. Thank you, Assemblymember. And I'll give you
Of
the
course.
floor.
Well, thank you. And I want to thank everybody for your attention to this really important issue. I think in my 6 years serving the state assembly, or almost 6 years, I consider this, I think, one of the most important issues the legislature has attempted to address. But what we found when we started looking at the Cartwright Act, which has not been amended since it was enacted in 1907, was that our antitrust law in California is, I'm going to use the term, deficient in several ways. And I submitted a letter. I don't want to go through and rehash what you probably have already read, but I'll just cover a couple of the highlights. The first issue is that there really is no prohibition on monopolies in California under the Cartwright Act. The federal law has that. Most other states have that. And there's no prohibition on monopolies exercising market power. And then the third issue, which is particularly relevant to the emergence of what I call mega tech companies, or large big tech companies, is that the test for injury in antitrust law, both in federal law and most states, is simply unable to actually capture the type of injury that big tech companies may be inflicting on people or the marketplace or competition. And what I mean by that is that the typical test for monopoly power in federal antitrust law, as you probably know, is market dominance combined with the ability to raise prices for your product without losing customers. That's probably the most simple formulation of it. Well, if you're a large social media company, and I will refrain from using any names this hearing, but if you're, say, a large $1 trillion+ market cap social media company, and you have, say, billions of users, and you don't charge anything for your product up front, you allow everyone to be on it for free, to sign up for an account, regardless of age, regardless of anything else. Anybody can sign up, and then you make your profit on the back end by data mining the use, using algorithms to keep people engaged in the content, using algorithms to affect young people's brain chemistry, for example, to keep them engaged. And so you have people on this platform for free, ostensibly, and you're data mining their use. And then that data that you've amassed over time allows you to sell to third-party marketers and make billions upon billions of dollars a month. And so the antitrust test in federal law would simply never capture that behavior. I'm not presupposing that any particular company or set of companies is engaging in anti-competitive behavior. But what I am suggesting is that our antitrust law, as it currently stands federally and certainly in California, is simply unable to capture that behavior, even if it is profoundly anti-competitive. And so that's the reason we passed ACR 95, me and Assemblymember Buffy Wicks. And we would like you to look at those questions and see whether this law that's been on the books for, head math here, 115 years and has never been reformed or modernized, and may need to be revised. We may need to give our Attorney General or other law enforcement officials some more tools to be able to look at some of these issues along the lines of what I've tried to outline here today. And I would ask respectfully that you would consider doing this all in one package. And some of that is because I think that's the intent of what we're trying to ask you for help with. I will say we did have a lot of extensive talks with the Attorney General of California and came close to introducing a bill to revise the Cartwright Act. But what we finally found is we just don't quite have enough information. And if you're going to do something like this, I think you need to do it right, and you need to do it in a very informed way. That's why we're asking for your help today. So part of it is, I think, separating out the monopoly issue from standard of injury issue is problematic for three reasons. One would be not the intent of the bill, but that's okay. The second would be, I think it's those two issues are intertwined analytically. And the third reason I believe that would be problematic is having moved some fairly difficult, rather unpopular with the tech community, privacy related and children protection related bills through this legislature over the last 4 years in particular. Some of which I got to the governor, some of which I didn't, some of which got signed into law, some of which got vetoed. I have learned that these are tough votes for legislators. If you came back with an absolutely perfect, I mean, it was perfect as a human endeavor could be, suggestion for a piece of legislation that would modernize the Cartwright Act and truly capture all the anti-competitive behavior that may be going on in California, it would still be a tough vote. It would be a tough vote to get to 41 in the Assembly. It'd be a tough vote in Judiciary Committee. It'd be a tough vote to get to 21 in the Senate. It'd be a tough vote to get through Senate Judiciary Committee. And it might be a tough vote to get through appropriations if it's found to be key fiscal for some reason. So whenever you're looking at that, you want to, if it's an uphill climb and it's a tough vote for legislators, no matter who is in the legislative body at that time, it's just simply easier to ask for them to make one tough vote than to make two. And I think that's a practical concern that does not fall outside the ambit of the scope of what we've asked you to study. So with that, I will conclude my remarks and thank you again for your attention to this. And I'm very glad that you're going to be taking it up and that we've got some scholars that are serious about good public policy that are going to be hopefully informing the legislature and my former colleagues and they're soon to be former colleagues. I'm out of office December 1st, so, and the Attorney General and the governor and everybody else. I think it's time the Cartwright Act got modernized, and I want to make sure that we do it as right as we can do it for the protection of competition and innovation in California. So thank you.
Thank you. Brian?
I think we would move on to talking about the memo and its supplements. The Assembly member can stick around if he wants to be available as a resource, or if your schedule requires you to be elsewhere now, that's fine too. We will be talking about your letter, and it was clear, we understand it. So memo 2250 was really about framing the conduct of the work. The more I learn about this area of law, the more I appreciate how deep it is and broad, and how much expertise is out in the world that could be available to us, but we don't have in-house. And so my first thought was to think about whether it would be possible to take small bites as a way of easing the commission into the subject matter and the staff. And that possibility is discussed in the memo. The other possibility that's discussed in the memo is a holistic approach. And, as I say in the memo, the holistic approach may be necessary if the separate issues, the subtopics in this broad study area are inextricable in some way. If you can only really understand and grapple with an issue in connection with another issue or set of issues, then it wouldn't work to segment the work. We'd have to do it all at once. And I was hoping that we could segment it because of the practical advantages in terms of acquiring the necessary information and sort of sequencing the work. But we received input first from, and this is discussed in the supplements, first from Cheryl Johnson, I met Cheryl when I was on a call with the three people from the antitrust section of the California Lawyers Association. And I have to say, because they really wanted me to be clear about this, that when I talk to people at the antitrust section of CLA, they are not speaking for the section. So they're speaking as individuals who happen to be members of the section. And so they're interested in providing assistance, but they're probably not going to be providing positions. And my sense is that's because the section is a balanced body of people from different perspectives, and there's not a lot of agreement. So I spoke with them. I met Cheryl through that conversation, and then she and I have spoken a couple of times since, and she submitted the materials that I attached to the main memo, where she summarized helpfully some examples of other broad reform studies in the antitrust area. So she wrote, or she spoke to me, actually, it wasn't a letter, we had a conversation about the issue presented in the main memos, incremental versus holistic. And she was of a mind that we have to do it holistically, that was the legislature's intent, that it be done as a package deal, and that really there were strong connections between the issues and they needed to be addressed together. And then subsequent to that conversation, I released the first supplement where I paraphrased her position for her, told her I was going to be doing that. It was with her permission. And again, it's her individual view, not the section's view. Then we got the two letters. One was from Assemblymember Cunningham, and the other was from Ms. Bauer representing, and I'm not remembering the acronym, I'm sorry. The United Food and Commercial Workers Western States Council. And both of those letters made similar arguments, which were consistent with what Ms. Johnson had opined, that the study should be conducted holistically. It should not be done in pieces. And those two letters in particular cautioned against trying to do incremental bills, introductions in the legislature. And that's consistent with what Assemblymember Cunningham said here this morning, that these are tough votes. It's better to give a complete package and see what the legislature thinks than try to take baby steps, because that just means a string of tough votes. The other point that was made that I thought was interesting and noteworthy with respect to the inextricability. The letter from Ms. Bauer, I think it was, points out that there are two existing jurisprudential obstacles to enforcing antitrust against large tech companies in California. One is the fact that the Cartwright Act does not contain a prohibition on single company monopolies. So that's a threshold issue. It's just not prohibited currently under California law, so you can't enforce under California law. And then the other thing is the standard of injury, and this is what another point that Assemblymember Cunningham was making. Because the standard of injury is based on price to consumers, it doesn't capture anti-competitive harms of other kinds that may exist in companies that provide services for free. And for free in the sense that they don't charge users a price for the service. They make their money by capturing data and attention from their customers. And so those are two independent obstacles. If you simply added a prohibition on monopoly without adjusting the standard of injury, you'd have the legal foundation to raise the issue, but you wouldn't be able to reach much of the anti-competitive conduct that's of concern to the legislature. Conversely, if you just fixed the standard, but you didn't have a prohibition on monopoly in California, then you couldn't apply that standard. So the argument is that both of those two issues are necessary, but neither is sufficient on its own. That in order to address this issue that the legislature has referred to us for study, you need to have both of those components in the mix. And I think that Assemblymember Cunningham argued this morning that not just those two issues, that it ought to be a broad, holistic look. I found that pretty persuasive. As much as I was predisposed to prefer an incremental approach because of the sort of process benefits, I think I was persuaded that the commission ought to take on the whole thing at once. And so we will first, I think we should talk about that. And then depending on what the commission decides, then we can talk about how to effectuate it.
Okay, do any commissioners wish to speak on the issue just raised by Brian? Commissioner King?
Yeah, I don't necessarily see this as an either or, because, you know, by definition, we're not going to be able to tackle all of antitrust law in one giant bite in terms of cognitively going through it. You're going to have to break it down into discrete chunks. But I think the obvious answer is that no recommendations should be put forward until we're done with the analysis, so that the recommendations are all in one chunk. But the analysis is by definition going to be in multiple chunks because it's just too big of a topic for us to study. I have a question. I don't know if the assembly member has a thought on this, but isn't there a lot of similar activity going on the federal level? Because just from my perusing on the internet, you know, Congressman Nadler in New York had a huge subcommittee look at this from 2019 to 2021, and they published their results in July of 2022 with very similar concerns. I mean, the subcommittee report specifically said they were concerned about the definition of injury in the Clayton Act. And so it seems to me that from July 2022, at least the federal level, they're starting to write laws about how to address that. And I'm a little concerned, you know, obviously California has different priorities. A lot of these big tech companies are here so that we have different interests and maybe greater urgency. But how do we reconcile not stepping on what the feds are doing or running counter to it or running parallel to it? Or are we even going into this with the assumption that Congressman Nadler's committee report is sort of a template for what we're contemplating here? Because they did a huge study. I haven't read it, but I looked at the executive summary, and it directly addressed a lot of the things we're discussing here.
Assembly Member Cunningham, would you like to offer any thoughts on the questions raised?
Sure. I think that's a great point, and I do think we're seeing some movement on the federal level with respect to the definition of injury issue. I would probably just offer a couple thoughts. One is, you know, the work can be done in parallel. I mean, a lot of other states, New York in particular, being pretty sizable, have much more aggressive and robust antitrust laws on the books that aren't in contrast or conflict with the Clayton Act or Sherman Act and all its interpretive case law. And the federal government, I have never served in Congress, but from my observations, it tends to take a long time for the federal government to revise statutes and enact laws that change longstanding statutes. You know, in the privacy space, you know, I worked on AB 2273 with Assemblymember Wicks. We got that signed into law by the governor this year. It's the age appropriate design code for the internet. You know, we took that from, it's modeled off of a law that was enacted a year ago in the United Kingdom. You know, we had meetings with people in DC, and there's a lot of interest in doing something similar for child protection online in DC. But it came to my attention in those conversations that the primary federal law protecting children online has not been amended since 1996 or something like that. So I think that there is action on the federal level. I don't think that precludes California from potentially modernizing the Cartwright Act. I think, you know, it's something to keep an eye on. But if I were wagering, I would wager the federal antitrust laws will probably take several years yet for that. And the reality is too, I mean, the balance of power in Congress changes about every 2 years nowadays, and then people change in the White House, you know, every 4 years or 8 years. So it's sort of, you can get a lot of momentum, and then one election result can stall that all out on the federal level. So that's another reason I think it just takes longer.
Okay,
Are there
that makes a lot of
other
sense. Thank you.
Are there other commissioners who'd like to make points? Commissioner Simpson?
Yeah, and just this is and maybe Mr. Cunningham can help as well. This is, I'll confess, a totally new issue for me. This is not school finance or education policy that I did for multiple decades in the legislature. But Mr. Cunningham, the nature of the injury is the injured party. It sounds to me like that's not the consumer who's using the social media. I don't do social media at all either. But is it the advertisers who are left out or charged more because the largest social media companies have more consumer data that they can leverage to increase the price of advertising? The nature of the injury is one I'm not sure I understand.
Yeah, I think that's a great point. I think there's a couple different potential types of injury, if you will. One would be what you identified. Everybody has to go to the same one or two social media or internet advertising companies because they dominate the market, and then the prices those companies are able to charge are above what they would be in a competitive market. That's probably the simple one. But the price analysis, you know, you could capture that under the existing Sherman Act and Clayton Act probably, because there is a price component, something, you know, you're charging for advertising, and in a competitive market, the price should be X and it's X plus Y because of the market dominance. So that's one nature of injury. Another is the anti-competitive impact in that, and here I sort of have to use a name of a company because there's no other way to really illustrate it. But when Facebook was the biggest social media company in the world, Instagram started to get big, and actually there was data that among the millennial generation, Instagram was growing faster than Facebook was. Facebook simply bought Instagram, and then same thing happened a few years later with WhatsApp, the messaging service, and then integrated it into its platform. So, you know, where you have companies that are monopolistic in size that have so much money that any potential competitor that gets, you know, to $1 billion, $5 billion in revenue, 100 million users, whatever threshold it is, that might be a more innovative product that people like better. But the larger dominant monopoly is able to, you know, using 10% of their monthly profits, buy up the competitor as it's starting to get larger. I mean, that's a problem. Now, I will say a caveat on that: the FTC did approve that merger. There's some, me included, that think that that was probably a mistake, but it did get some scrutiny at the federal level. So that's another nature of injury that the entire marketplace and the competition and the innovation that and the antitrust laws exist to protect both the consumer and other businesses that are competitors to the monopolistic entity. So that could be another, and then a third potential injury, and this one's going to take, I think, a lot of studying and serious thought, because it wasn't obvious to me when I was trying to draft a bill how to really do this. But there's a consumer welfare impact as well. So if a particular company is so dominant and so monopolistic that it is able to do things that may be harming its own users, the current test would never capture that, because again, they're not charging anything for that service. And that harm could be, I don't know, designing algorithms that addict young people. And so rather than competing and making your product better, you're using neuroscience to create slot machine casino type things that addict people. And that arguably is anti-competitive. You're not innovating, you're using a product design feature that in essence captures people, and then you're able to monetize their use over potentially a lifetime, and that's something that might be looked at as a different type of injury.
Thank you.
Thank you. Brian, on the issue before us, I will disclose that I have had some practice experience in the antitrust area. That experience does not lead me to any predisposition on the substance of what we're going to be looking at. It does lead me to a conclusion that aligns with what we've already heard, which is there is no way to segment this, particularly at the beginning, with a commission that may not have a grounding in antitrust law. So I would support proceeding in what you refer to as a holistic fashion, even if once we, as a commission, get our sea legs in the material, we begin to see ways to segment pieces of the project for study, with a goal of creating a single product at the end, even if we segment for purposes of study.
Does any commissioner see it differently?
Makes sense to me.
Do we want to ask whether anyone in the audience wants to argue for a different approach?
Yes, that was my next question. Are we able to identify what topics members of the public are here for?
Not with precision, but there are certainly people here for this topic. I recognize a number of names. So
Brian, before we do that, any other commissioner have any comments they'd like to make before we open the floor to members of the public? Hearing none, Brian.
Well, and I would ask, first of all, if anybody in the public wants to be heard, we use the raise hand button to signal that. But I would ask that people who agree with the direction the commission is going, not take the time to argue in favor of a proposal that seems like it's already supported by the commissioners unanimously. So it'd be most useful to have comments from people who have a different view rather than people saying, I agree. I don't see any hands. So yeah, let's do a motion and a vote on this, that the decision is to proceed as I would think the motion would be the one that the Commissioner Huebner just framed for us.
So moved.
Is there a second?
Second.
All right, I'm going to call the roll with the understanding that a couple of members are not currently present. Commissioner King.
Aye.
Commissioner McAllister.
Aye.
Commissioner Huebner.
Aye.
Commissioner Simpson.
Aye.
Commissioner Cubas.
Aye.
Okay. So that is unanimous decision with the absence of Commissioners Carrillo and Jenkins. Thank you.
Brian, is there anything else we need to do on this item today?
Yeah, I'd like to talk a little bit about what I'm going to be doing for January. And there are a couple of prongs here that I think are worth talking about. In addition to the observation that the US Congress is considering antitrust reform, it's also the case that the Uniform Law Commission has a drafting committee now. They approved a drafting committee on antitrust law reform for states. And I have spoken with the president of the ULC, Dan Robbins, who's also a member of the California Commission on Uniform State Laws, about this. He reached out and we've exchanged email. One of the things that the ULC did that I think is useful, and this was also suggested to me by Cheryl Johnson, excuse me, as an individual, was that we conduct a series of background briefings for the commission. That the ULC, I think they worked with a Professor Dan Crane from the University of Michigan Law School, and he put together, I think, 4, maybe 5 presentations that each one covered a distinct subtopic that make up the totality of sort of the issue space for this study. And those presentations were, I believe, by Zoom, with an opportunity for the ULC committee members to ask questions. And I think it would be helpful to do something similar here, that in tandem with the deliberative work, that we hold a series of presentations with people explaining the background law and the areas of focus and concern, perceived problems, proposed solutions, that kind of thing, within specific subtopic subject areas. And, it'd be easy to either integrate that into our existing meeting schedule. It would probably mean making the meetings maybe an hour longer, so that we would have time for it. And I'd be interested in knowing whether the commission, before I start the work with people to try and set that up, is that something you'd be interested in?
Yeah.
Okay. So the other piece of it, and this kind of goes back to a discussion that we had a couple of meetings ago about the use of subcommittees. And I'm not proposing a subcommittee of commission members, but I think there might be some value in following a model similar to the Stiegler report that was described in the materials that Cheryl Johnson provided that were attached to, I think, the main memo, where the Stiegler committee that was looking at these kinds of issues set up small working groups of experts in different subject areas. So, for example, standard of injury versus merger standards versus whatever else we see as like the appropriate places to subdivide the issue space. And those smaller working groups of experts collaborated and came up with a consensus document that identified perceived deficiencies in existing law and proposed substantive reforms to address them. And I skimmed the eventual cumulative report that they issued, which incorporated the work of these subgroups. but I haven't studied it closely, but I assume that either they did or we could ensure that pros and cons are included, so that it's not just here's what our group advocates, but a panel of experts to say, Commission, we've studied this closely, here's our report. And then the commission, once we have all of that input, could use it as the starting point for our own deliberations about which issues you want to tackle and what solutions you want to pursue. The part of the reason that appeals to me is that, as I said, this study is different from, I think, any that I've seen the commission take on before in terms of the magnitude of the information and also the availability of expertise. There are a lot of people out there who have made it their careers to work on these issues. There are also bodies like this, the commissioner Congressman Nadler, I think it was, his committee report, the Stigler report. There are other people out there who have done work in this area whose work could be synthesized into the commission's considerations. And so ordinarily, when we're working on a smaller project, our practice has been to sort of become the experts in that subject area and be the ones who did the heavy lifting and innovating in terms of figuring out how to solve problems. Here, I think that would be much more difficult for the commission to do, and might also be inefficient in the sense that there's already so much out there in terms of other studies and experts. And so I guess I'm advocating for a slightly different model, which would be that we would ask experts to curate the issues for us and then start our deliberative process after they've provided the input on the substance. And I see a hand from Commissioner Heeman.
Yeah, Brian, I, speaking as a rank and file commissioner, would endorse that. The concerns I previously raised about subcommittees arise from concerns about small groups of commissioners engaging in coordinated activity out of the sight of the public and the full commission. Arranging working groups that do not include commissioners is a completely anodyne suggestion in my view. And in prior time on the commission, I've seen the staff organize outside working groups that have been immensely helpful. My other concern, if we don't do what you're suggesting, is this project could outlive all of us actuarially. And so organizing it really well at the beginning so that we've got a dozen moving parts moving simultaneously gives us a chance of actually making timely progress. So I would fully support what you're suggesting. It would be important in my view to make sure that any little groups that are put together are balanced in some way, and balanced is the wrong word, but so that there isn't capture of particular groups by fixed opinion.
Yeah. One of the complications, and this is something we talked about when we talked about the use of subcommittees, is that the Bagley-Keene Open Meeting Act applies to advisory bodies that are created by bodies subject to the Bagley-Keene. So I'm looking back at my memo from, I think it was August. The Government Code Section 11-121 applies to, as I said, advisory bodies having 3 or more members that are created by formal action of another body. And I'm reading here from the Department of Justice's treatise on Bagley-Keene. And so if we were to set up these working groups, if they were to have 3 or more members, which I think would probably be desirable, and if they are formally created by the commission, then they would be governed by Bagley-Keene. And they would have to agendize, they would have to restrict their communications to open meetings. They would have to, give advance notice to the public, allow the public in, allow the public to comment. Those are all great value for a public deliberative body. I don't know that they're great for a study group that's going to be preparing a report. The analogy being, if we were to contract with a single academic expert, and as we have done many times, and say, prepare us a background report on this issue, this legal question, they could do whatever they wanted in terms of how they went about conducting their research, who they consulted, how they drafted, et cetera. There would be no public participation within that work by that consultant. But if we fall into this area within Bagley-Keene where there's 3 or more and it's created by formal action, then it would be a public deliberative body subject to all of those transparency requirements.
A question about that though, Brian, in the past, have staff not assembled more than one person to provide input to staff?
Well, that's the thing. The answer is yes, we have. The DOJ treatise says, when a body, I'll just read 2 paragraphs briefly. When a body authorizes or directs an individual to create a new body, which is what we're talking about, that body is deemed to have been created by formal action of the parent body, even if the individual makes all decisions regarding composition of the committee. The same result would apply where the individual states an intention to create an advisory body, but seeks approval or ratification of that decision by the body. Finally, the body will probably be deemed to have acted by formal action whenever the chair of the body, acting in his or her official capacity, creates an advisory committee. Ultimately, unless the advisory committee is created by staff or an individual board member, independent of the body's authorization or desires, it probably should be viewed as having been created by formal action of the body. So Bagley-Keene would apply unless the staff creates the body, or a single member other than the chair, apparently. Single member does it without the formal approval of the body, which puts us in a weird space because we're talking about it right now because I want your assent for me to do that kind of staff work. But if I go too far in asking, if I give too large a measure of control or permission, then we fall into Bagley-Keene. So I guess I'm just notifying you that it's my intention at the staff level to create these working groups, which will eventually prepare reports for submission to the commission. But I'm not going to ask you to approve it because I think that would cross a line. And I really do think that in this instance, as long as the groups are constituted in a way that's fair and inclusive of different perspectives, which I would seek to do, I think that a study group is qualitatively different from a public deliberative body, and that it would be a significant obstacle to effective work to subject such a group to all the requirements of Bagley-Keene. If anyone thinks that my intention is problematic, you can let me know that. But for now, I'm just reporting to you that it's my intention to set up these groups. Again, seeking balance of perspectives and expertise to prepare reports for the commission on the different subject areas that we're going to be examining. Okay.
Hearing no objection. Brian, it would be over my line if staff were looking to use groups to make specific recommendations about outcomes to the commission. But it sounds to me like that's not what you're saying may occur, that what will occur is discussion and clarification of issues for informational purposes.
And would it be?
Is that
probably-
accurate?
I think so. But I think it would include identification of the sort of the potential, the perceived problems in existing law and the sort of state of play across the nation of perceived reforms with pros and cons. So it'd be like a survey of the problems and solutions that are out there without necessarily advocacy for the commission to reach a certain result.
That sounds informational to me. Thank you.
All right. So I think that that's sufficient for my purposes right now. And I would do that kind of work. I would do the 2 tracks. I'd be setting up these educational background briefings for the commission, which would occur at meetings. And I would separately be doing the staff work to set up these small working groups to help us collect information for the commission's deliberative process. The result of that information, because it would be provided to the commission, would be public. The product would be public documents. But the process by which these consultants, advisors prepare their reports would not be public.
Is there an objection on the part of any commissioners to another element Brian suggested, which is extending certain meetings by an hour in order to accommodate the informational exchanges?
Sounds good.
Hearing no objection.
And the alternative, which I would probably discuss with the chair before acting on, and it just sort of depends. I haven't thought fully through like how much information we need and how many of these sessions to schedule, how fast we should try to achieve them. Another possibility would be to just schedule some special meetings that are purely these informational background meetings. So just throw in a 1-hour meeting somewhere and say, commissioners, attend if you can. You'll have a chance to ask questions of the expert after the presentation. No decisions required. And the resulting video on YouTube as with our regular meetings. So that would be an extra burden, not just in terms of extending time of the meetings, but also possibly slotting in some of these narrow special purpose events. And I wouldn't do that, like I said, without consulting with the chair first. Okay.
Commissioner Simpson?
Yeah, just a quick on related topic. The one thing maybe in this process of getting some background information, the one thing I don't recall seeing in the memos was what power does a state like California have over these kinds of companies? I can see how the CCPA, because what's being protected there is the California consumers and their personal data. But if the injury is something that is experienced by other businesses whose prices of advertising go up because there's only is that the kind of thing the state of California has any power over in the first place? That's one of the kind of thing I'd be interested in.
Yeah, and I don't want to broach the issue at all because I don't know enough about it yet to have a useful conversation. But that is one of the issues, is the sort of the jurisdictional reach of California and the issue of the scope of any federal preemption. So we would definitely look at that, and I think that might be an appropriate topic for one of these informational briefings.
Great, thank you.
Would the commissioners object if I took a 5-minute break?
as long as we can too.
And
Yeah.
fine with-
Hearing no objection, let's take a 5-minute break.
Thank you.